Parviz Ravi, attorney at law, have been practicing for over 20 years. Our office is located by San Francisco Airport, specializing in employment law. Today's topic, arbitration agreements in California, part 2. If you're considering a job and have been asked to sign an arbitration agreement, or have a job and have already signed an arbitration agreement with your current employer, it is important to understand exactly how that agreement may impact on your rights. An arbitration agreement is a contract or a clause within a larger contract signed between you and your employer where all parties involved agree to resolve dispute through arbitration rather than a civil lawsuit in California court. In other words, by signing an arbitration agreement, you are waiving your rights to proceed in court and having a jury trial to resolve your disputes, and instead agree to submit your disputes to a neutral third person called an arbitrator for a final decision. Such agreements are typically found inside of larger agreements and are rarely their own documents. Some employers even include arbitration agreements in a larger packet of paperwork without mentioning it. So be sure to review everything you're asked to sign carefully. If you find yourself in a situation, whether you are applying for a new job or at your current job, and you are presented with an arbitration agreement from your prospective or current employer to sign, here are a few things for you to consider before signing it. Whether the arbitration agreement was presented to you as a standalone document with a separate title and heading for each section. Your employer should not bury an arbitration agreement within its employee handbook. Whether you were provided with a translated copy of the arbitration agreement in your native language. If your first language is not English and you have language barrier that could prevent you from understanding the contents of the arbitration agreement, your employer should offer you an opportunity to review a translated copy of the arbitration agreement that you can read and understand what you are agreeing to and signing. Whether you were provided with adequate time to review the arbitration agreement prior to signing it. Your employer must not impose unreasonable time limitations on you to review and sign, such as all the documents must be signed and returned within a few hours of receipt. Whether the terms of the arbitration agreement were short and simple so that you could understand the terms. Whether you were provided with the opportunity to ask questions or consult with legal counsel prior to signing the arbitration agreement. If you were given access to the arbitration agreement electronically, whether your access was through mobile app or desktop computer, or whether there was a system in place that you could scroll and review the arbitration agreement before you had the ability to check an I agree box or sign and initial the agreement, or to ensure that you, only you, no one else, could have gained access to the arbitration agreement and sign. If you have any questions on this topic, please contact my office for free consultation. Please be sure to like and subscribe and turn on your notification.